40 years of notebooks, and the idea that changed everything. I started keeping engineering notebooks in 1981. My supervisor at the time, a rigorous woman named Dr. Patricia Assay, who tolerated no imprecision and expected documentation of everything, told me on my first week that an engineer without a notebook is an engineer without a memory, and that an engineer without a memory is not an engineer at all. I took that seriously. I have taken it seriously for 40 years. The notebooks are identical, hardcover, grid-lined dark green, numbered sequentially on the spine. I am currently on volume 47. Each entry is dated, timed, and signed. When I worked at the firm, each page was countersigned by a colleague as witness to the work being done and when. This was standard practice for patent development in any serious engineering environment. After I retired, I continued the habit because the habit was correct, and retirement does not change what is correct. My name is Dorothea. I am 70 years old. I spent 38 years as a mechanical engineer, specializing in consumer product design, the unglamorous end of the field where the work is about making things that ordinary people use every day function better than they did before. I am proud of that work. I patented 6 products during my career, all under the firm's name, which is how it works when you are an employee. When I retired, I told myself that the next one would be under mine. Grandma always said, the best ideas come when your hands are busy and your mind is free. Retirement gives you both at once. The kitchen gadget idea arrived in the 3rd year of my retirement, on a Tuesday morning when I was making breakfast and encountered, for what felt like the 400th time, a problem that no existing product adequately solved. I will not describe the device in detail because the patent is now a matter of public record and the technical specifications are available for anyone who wants them. What I will tell you is that it addressed a genuine gap in a high-volume consumer product category, and that when I showed it to the 3 friends I trusted most, all of whom had spent careers in different technical fields, each of them said a version of the same thing. Why does this not already exist? I developed the prototype over 14 months. I documented every iteration in the notebook, every sketch, every calculation, minus one failed version and the reason it failed, every successful adjustment and the reasoning behind it. Volume 43 covers the first prototype. Volume 44 covers the refinement period. Volume 45 covers the testing phase, including the dates and names of the friends who witnessed the tests and signed the relevant pages. By the time I approached my grandson Kyle, I had a working prototype, 14 months of dated documentation, and a product that 3 engineers and 2 non-engineers had independently assessed as commercially viable. Kyle was 32 years old and a patent attorney at a firm that handled intellectual property for technology and consumer product clients. He was the obvious person to ask. He had grown up watching me work. He knew what engineering notebooks were and what they meant. He picked up the prototype, turned it over in his hands, and said the words that I now understand were the beginning of everything that went wrong. This is interesting, Grandma. Let me look into the patent process for something like this. It might need some refinement, but I think there is something here. The months of waiting and the television set that told me everything. Kyle was busy. This was not surprising. He was a working attorney at a demanding firm and I was not his only obligation, nor should I have been. When I followed up in month 2, he said he was looking into it. In month 3, he said the patent search was taking longer than expected. In month 4, he said there were some classification questions that needed resolving. In month 5, he said he had been pulled onto a major client matter and would get back to me as soon as it concluded. I was patient. I am always patient. Engineers are trained to be patient because the work demands it, and impatience produces errors. I noted each conversation in my notebook with the date and the substance of what he had said. This was habit. I did not note it because I suspected anything. I noted it because I note everything. And then it was a Thursday evening in November, and I was watching television, and my invention appeared on the screen. Not a product like it, not an inspiration drawn from it. My invention. The geometry of the mechanism, the specific articulation point, the handle configuration that I had redesigned 11 times before, arriving at the version that worked correctly, presented on a nationally broadcast entrepreneurship program by a young man in a well-fitted jacket, who was describing the problem it solved in language so close to the language in my notebook that I had to sit down. Grandma always said, "You know your own work the way you know your own handwriting. There is no mistaking it, regardless of whose name is on it." The young man was Kyle, my grandson, 33 years old now, standing in front of four investors and an audience of millions, pitching my product as his own original invention, describing the 18 months of development he had put into it, and accepting, on camera, a $2 million investment deal that the lead investor said was one of the clearest commercial opportunities she had seen in 3 seasons of the program. I watched the segment twice. The second time I had my notebook open on my lap. I was not looking for confirmation. I did not need confirmation. I was making notes, dated and timed as I had always done, because I understood immediately that what I was watching was not a coincidence or an inspiration or a parallel development. What I was watching was theft, conducted by someone who had grown up in my house, eaten at my table, and learned from watching me work exactly what an engineering notebook meant and exactly how much evidence it contained. He had known the notebooks existed. He had been counting on me not to use them. I called my attorney the following morning. Not Kyle, not anyone in the family. My attorney, a woman named Frances, who had handled my affairs for 15 years, who listened to the full account without interruption and then said, with the measured calm of someone doing rapid professional assessment, "Dorothea, do you have the notebooks?" I told her I had 45 of them. She said, "Bring me volumes 43 through 45 and the prototype." I said I would be there in 2 hours. Frances, the patent office, and the documentation that could not be argued with. Frances spent 4 hours with the notebooks on the day I brought them. She did not read every page, but she read the relevant sections with the careful attention of someone building an understanding that will need to hold up under pressure. She looked at the dates. She looked at the witness signatures on each page. She looked at the prototype and compared it, page by page, with the sketches in volume 43. When she was done, she said, "This is one of the strongest invention priority cases I have seen in 20 years of practice. The documentation is better than most firms produce for their own patents. Dr. Assay, whoever she was, did you an extraordinary service." I told her Dr. Assay had retired to Accra in 2003 and was, as far as I knew, still keeping notebooks. Grandma always said, "A good habit maintained long enough becomes its own kind of armor. You do not always know what it is protecting you from until the day you need it." The patent filing Kyle had submitted was dated 8 months after my first conversation with him about the device. Frances pulled it from the public database and read it alongside my notebooks. The claims, language in the patent, tracked the technical approach, documented in my volume 43 with a specificity that could not be explained by independent development. Several of the claim terms were unusual formulations that I had arrived at through a specific engineering reasoning process, documented across 6 pages of volume 43. The probability that someone else had independently arrived at the same formulations was. The expert Francis subsequently engaged described it effectively zero. Kyle had filed under his own name as sole inventor. He had listed his employer firm's address as the correspondence address, which meant the firm had been aware of or involved in the filing. Francis flagged this as a separate avenue of liability. She also noted that Kyle, as a licensed patent attorney, had a professional obligation not to misrepresent inventorship on a patent application. Doing so was not merely a civil wrong, it was a violation of the rules of professional conduct that govern attorney licensing. We filed the patent interference proceeding within 3 weeks. This is the formal mechanism for challenging inventorship of a pending or granted patent, and it requires the challenger to establish prior conception and reduction to practice of the invention. The 44 dated, witnessed, sequentially numbered notebooks established conception with a precision that most patent attorneys spend careers trying to approximate and never quite achieve. Kyle's attorney, who was not from his own firm for obvious reasons, apparently reviewed the notebooks and advised him to consider his options carefully. Kyle apparently did not immediately take that advice. The hearing, the notebooks on the table, and the face of a man who had miscalculated. The patent interference hearing took place 7 months after Francis filed the proceeding. In that time, Kyle had maintained publicly that the invention was his, had made several additional media appearances related to the television program investment, and had begun the process of commercializing the product through a company he had established with the $2 million. He had, in other words, moved forward as if the proceeding was a nuisance rather than a reckoning. Francis placed volumes 43, 44, and 45 on the table at the hearing. She also placed the prototype, the witness statements she had collected from the 3 friends who had observed and signed the testing phase, and a report from the independent technical expert who had compared the patent claims to the notebook documentation. The report was 42 pages long. Its conclusion was expressed in one sentence at the end of the executive summary. The sentence said, "The inventive concept, the reduction to practice, and the specific technical claims of the contested patent are documented in the challenger's notebooks with a priority date that precedes the respondent's filing by 14 months. Grandma always said, the truth does not need to be argued. It needs to be shown. Show it clearly enough and the argument becomes unnecessary." Kyle's attorney made the available arguments: independent development, parallel innovation, inspiration drawn from conversations rather than documentation. Each argument met the notebooks. Each argument met the witness signatures and the dates and the sequential numbering and the specific technical reasoning that the notebooks contained. By the end of the first day of the hearing, the quality of the arguments had changed in a way that Francis described to me afterward as predictable. The hearing officer's determination came 6 weeks later. The inventorship of the patent was reassigned to me as sole inventor. The patent, with its full claim scope, transferred to my name. The $2 million investment, which had been made on the basis of a patent held by Kyle, became a matter for the subsequent civil litigation, which Francis had already filed in parallel. Kyle's firm had, by the time the determination came, already initiated its own internal review of his conduct. A patent attorney who files a false inventorship declaration on a patent application has violated professional conduct rules at the federal level, where patent practice is regulated, and at the state level governing his general law license. Both regulatory bodies had received the hearing determination and the supporting documentation. By the time the civil case went to trial, he was 33 years old, and regulatory proceedings were open against him. Simultaneously, he had moved forward as if the notebooks did not exist. The notebooks had existed for 40 years. The civil judgment, the license, and what $3 million means. The civil trial covered 3 categories of damages. First, the $2 million from the television investment, which had been obtained on the basis of a fraudulently held patent and which the court found should be disgorged in full. Second, compensatory damages for the 14 months of commercial delay caused by Kyle's unauthorized filing, during which the product could have been legitimately in market under my name. Third, punitive damages reflecting the deliberate and premeditated nature of the misappropriation. The total judgment was $5 million, $2 million in disgorgement, and $3 million in compensatory and punitive damages. Kyle's attorney argued the punitive component was excessive. The judge, who had read the hearing record and the expert report, disagreed in terms that Francis described as unusually direct for a civil damages ruling. She said the court found the conduct particularly egregious given the familial relationship, the professional knowledge the defendant had used to execute the scheme, and the deliberateness of the planning evidenced by the timing of the patent filing relative to the first conversation with the plaintiff. Premeditated. That was the word the judge used. He had planned it from the first conversation. Grandma always said, the cruelest betrayals are not done in anger. They are done calmly, over time, by someone who thought the plan all the way through. The United States Patent and Trademark Office revoked Kyle's registration as a patent practitioner. Without that registration, he could not practice patent law in any form. His State Bar Association, reviewing the same record, suspended his general law license pending a full disciplinary hearing. The disciplinary hearing, which concluded for months after the civil trial, resulted in revocation of his state license as well. Kyle was 35 years old, without a law license of any kind, with a $5 million civil judgment against him, and with a public record that any future employer in any field that requires professional licensing would find in the first 30 seconds of a background check. The $2 million investment was returned to the investor, who had been kept informed throughout the proceedings and who issued a brief public statement saying she was pleased the correct inventor had been identified, and that she looked forward to discussing a potential investment with me directly. We had that conversation. It was a good one. I want to be precise about the family dimension of this because I think it deserves honesty. Kyle's parents, my son and his wife, were devastated in a way that had nothing performative about it. They had not known. The investigation confirmed they had not known. Their grief at what he had done, and their grief at what the consequences had produced, were real, and I did not want to add to them. I am not at war with my son. I was at war with a theft. Those are different things, and I tried throughout to keep them separate. Volume 47 and what a notebook is really for. I am currently on volume 47. The entry for the day the civil judgment came through is dated, timed, and written in the same hand I have used since 1981. It says, judgment entered. $5 million. Patent confirmed in my name. 44 years of notebooks. Dr. S.A. was right about everything. The product is in market now. It launched 8 months after the civil trial under my name through a company I established with Francis's guidance and the investment from the television program's lead investor, who renegotiated the terms directly with me and who has been in every interaction since. Exactly the kind of business partner you hope to find. The product is doing well. I do not track the sales numbers daily because I am 70 years old and I have other things to do. But Francis sends me a quarterly summary and the summaries have been consistently good. I find this satisfying not primarily for the financial reason, though the financial reason is real, but because the thing works. It solves the problem it was designed to solve and people are using it in their kitchens every morning and not thinking about any of this, just thinking about breakfast. Grandma always said, the best measure of an invention is not the patent or the revenue, it is whether the thing does what you designed it to do for the person who needed it done. Kyle has not contacted me. I have not contacted him. This is not a position I expected to hold with my grandson at 70 years old, and I will not pretend it is comfortable. He made choices. The choices had consequences. The consequences are his to carry, not mine to soften. If he is ever ready for a different kind of conversation, that is a conversation I have not closed the door to. I have simply not opened it either, and I am at peace with that for now. I think about Dr. Issei sometimes. She retired to Accra and I lost touch with her over the years in the way you lose touch with colleagues when the decades accumulate and the distances are real, but I think about that first week, the instructions she gave me about notebooks, the specific tone she used when she said it, as if the habit was not optional but fundamental. I have wanted to write to her and tell her what the notebooks did, what they protected, what they proved, 40 years after she told me to start keeping them. I have not written yet. I am not sure I have the right words, but I am thinking about it, and when I find the right words, I will write them in volume 47 and date the entry, and then I will put them in a letter and send it. That is how I have always done things. Carefully, completely, with a record. Because a thing worth doing is worth documenting, and a thing worth documenting is worth protecting. Grandma always said, write it down, sign it, date it, and keep it somewhere safe. You may not know today what you will need to prove tomorrow, but the notebook will know. Thank you for watching. If this story found you today, I hope it reminded you of something important. Your work is yours, your ideas are yours, and the evidence of that belongs to you in the most durable form you can maintain. Write things down, date everything, keep the notebooks, and never, under any circumstances, hand your work to someone else and trust the process. Trust the documentation. The documentation does not get busy. It does not forget. It does not have other priorities. It simply waits, patient and accurate, until the day it is needed. Leave a comment if this